My name is David Malmo-Levine. I'm going to the Supreme Court of Canada on Friday the 13th of December 2002. I will be representing myself. I am arguing that cannabis dealing is protected by Sections 7 and 15 of our Constitution. That is, Sections 7 and 15 protect all harmless people. And while not all cannabis dealing is harmless, all proper cannabis dealing is harmless. If you know how to take people's concerns into account and address the concerns over lung damage and driving impaired, if you know how to address those concerns, then you are a responsible cannabis dealer and you won't be harming anyone and you'll be helping a lot of people and you should be included in Canadian society. I am joined on this constitutional challenge with two other cases, the Caine case and the Clay case. Representing Randy Caine is John Conroy, longtime social activist, and you've been to the court 8 times before, is that right?
Something like that.
All right, and you're representing Randy on civil possession charges. Maybe you would like to give yourself an introduction.
All right. The Caine case, in which I'm counsel, was started quite a few years ago, and for several reasons. One of them was to try and put an end to this my study versus your study debate that goes on, and to have expert witnesses come into a courtroom, be examined and cross-examined, and have an independent judge make findings of fact after listening to all the experts. And that was done in this case over quite a few years, and ultimately the case went to the BC Court of Appeal, and in the Court of Appeal, the court found, as a fact, all judges found, that the possession and use of marijuana does not pose a serious, substantial, significant, or even large risk to the public, but they found that the risk was slightly more than trivial. The Ontario Court of Appeal in Ms. Clay's case subsequently agreed with those findings of fact, and both courts of appeal have also agreed that the John Stuart Mill harm principle is a principle of fundamental justice in Canada, and that principle is that in a free and democratic society, you can essentially do whatever you want, so long as you don't cause harm to others, either directly or indirectly. And in law, the indirect term is focused on risk to the public. And at the moment, the question that will be before the court is what is the level of risk? The court having found no significant risk, and it being a matter of liberty because criminal law is involved, we will argue that before you can threaten liberty in a free and democratic society, that the weight of the authorities support that the risk has to be serious or significant. And that's essentially what the dissenting judge in the Court of Appeal found, that you can't threaten liberty in a free and democratic society for simply trivial conduct, but the risk to the public must be serious. And I'm fortified in the findings of the recent Senate committee, where the Senate committee concluded that really the risk should be of significant direct harm, and otherwise the criminal law shouldn't be used. So that's going to be one of the major issues in this case. Hopefully the Supreme Court of Canada will agree. The principle of fundamental justice includes the harm principle, and will decide that a significant risk of harm is required. So really the case involves even more than marijuana. It involves determining what the limits of the criminal law power are. How far can Parliament go in threatening people's liberty in a free and democratic society? When does private conduct move into the area of public domain so as to justify government, or give the government some sort of interest? We say that the possession and use of marijuana shouldn't be any of the government's business, and that's what we'll argue in the Supreme Court of Canada.
And next we have Chris Clay, who will be represented by Alan Young and Paul Burstein.
Yes.
And Chris is a longtime cannabis activist, hemp activist, and he was operating in London, Ontario, and he'll tell you his story.
Yeah, so I began in 1993. I opened the country's first hemp store. I was basically selling seeds and books and also hemp products. At the time, hemp was illegal to grow in Canada, and I was fighting the law on all of these different fronts. And it came up during my case that even having a hemp shirt was technically possession. If you sent it off to one of the government's analysts, they would classify it as a narcotic. But the main thrust of our case was similar to what John just described. that marijuana is relatively harmless compared to alcohol and tobacco. And we spent 3 weeks. We brought experts from across North America, and actually brought 2 commissioners from the Dane Commission. There were 5 of them in total, and in the early 70s they recommended that we decriminalize. And we brought them back to say that 25, it's actually now more than 30 years later, this law still hasn't been changed. And I came across this recent clipping I just wanted to show. This is from 1970 as well. It's a reprint that was in the Globe and Mail, where Ottawa was promising to ease the marijuana laws. And this is before I was born. I mean, the law should have been changed much, a long, long time ago. And obviously it hasn't. And I found a few quotes. I just wanted to remind the Liberals of a few things that they said. After the 1970 promise, then in 1980, Trudeau promised to move the cannabis offences to the Food and Drug Act and remove the possibility of imprisonment for simple possession. And John Gretchen was the Minister of Justice at the time, and he said that we hope to be in a position to present legislation to the House soon. And a few months later, he said that we want to change the form of the penalty and to modernize it. We do not think that once in a while, or we do think that once in a while we have to modernize laws which have been on the books for so long and do not cope with realities as they exist. So he's in a great position today. I think we all agree that Parliament should have made this change a long time ago. They should do it today. And if they don't follow through in the next few months, hopefully the courts will force them to.
And last but not least, we have Marc Emery, the financial wizard of this operation, the man who's managed to fund this campaign and allow scapegoats basically to fight back an illegal system that they would not normally have access to. Mr. Marc Emery.
Well, I'm not the only person contributing financially, but I'm probably one of the more substantial people who contributed to the various cases that have got to this point. I know we've made contributions to Mr. Clay's case, and Randy Caine's case, and certainly David Malmo-Levine's case. We paid for a lot of their defense work up till the present time, or at least large chunks of it. And 32 years after the Dane Commission came out and the Liberal government promised to change the marijuana laws, we're tired of waiting for Parliament to do that. So this is the only chance we'll get to the Supreme Court. When the Supreme Court rules, there will be no appeal for us in the courts any longer. If we lose and if we win, hopefully there will be no more appeal for the Government of Canada. And the issue will be determined. And I expect that it's a 5-day case, I would imagine, December 13th to 18th of this year, and the verdict or the judgment will come back from the Supreme Court around June to August of next year, 2003. So hopefully at this time next year, marijuana will be legal to be sold, to be grown, to be possessed, and that'll be a wonderful thing. And you can ask questions now.
If you have any.
If you have any.
That's some good ones there.
Well, I'll tell you one thing that the public ought to know is this will impact on all laws regarding gambling and prostitution as well. Because in this particular case, the court is going to be asked to determine if any consenting relationship should be legal and whether Parliament has the right to prescribe or restrict consenting behavior. So although it impacts on marijuana, it doesn't necessarily impact on any other law regarding drugs, but it does impact on other aspects of human interaction like gambling or prostitution. So it's well worth it for Canadians to understand what's being asked of the court, because it could bring the most substantial change in the Canadian landscape as regards civil liberties for Canadians.
Hey, we could go further than that. We could say that it could establish a precedent protecting all harmless people in the future, where the government couldn't just point to 10% of the population and say, all of you have to go into concentration camps now. Because legally, the government would, the onus of the burden of responsibility would be on the government to prove that those people were harmful. It wouldn't be up to the scapegoats to somehow prove that they're harmless.
Just remember, if you're going to say something groovy, the mics are over here.
Right, right.
Really
Sorry about
to make it
you want me to re-groove?
Well, just, if you want, we can hear you, but it's definitely off mic sounding.
All right, well, I'll jump right in there again and say that again, because I think it ought to be said. It's not only will harmless people like gamblers and people who prostitute or use prostitutes will be protected, and they ought to be protected, but all potential scapegoats in the future that the government might come up with if they lose pot smokers as a scapegoat, they might be protected as well if we drive home the point of being innocent until proven guilty, and the burden of responsibility rests upon the government to prove that there's harm. It's not up to the group of criminals to prove that they're harmless. I think that's a very important precedent we could set.
I think that it's important for the Canadian public to know and to remember that in 1982, we became a constitutional democracy. We were a parliamentary democracy before that. And so from 1982 forward, the Constitution of this country became the supreme law, and Parliament could no longer do whatever it wants to do, as it was able to in the past. And so Parliament is subject to Section 7 of the Charter, which says that we have the right to life, liberty, and the security of our person, and the right not to be deprived thereof except in accordance with principles of fundamental justice. That's what we're trying to establish, that if you charge somebody with a criminal offense, their liberty is threatened, the security of their person is threatened, and the question is, are you doing that in accordance with these fundamental principles? And we say that the government is not doing so. Now, the Charter also provides that the government can impose reasonable limits that are demonstrably justified in a free and democratic society. So that's where this onus of proof comes in. The government would have to essentially be found or accept that they are violating constitutional rights, and they then have to present some good reason and evidence as to why they are demonstrably justified in affecting people's constitutional rights in the circumstances. And that's where the onus should be in a free and democratic society. This case will raise some of those onuses and who has to prove what and get into the legal technicalities. But basically we know, as I said a moment ago, that the findings of fact on the evidence are greatly in our favor in terms of the lack of risk of harm to the public from this benign type of conduct.
I'd like to point out, there's been a lot of conjecture that the law hasn't been changed so far because of pressure from the United States. And I think that's probably true, and they've been guiding our drug policy since the 1920s when it was originally banned. And I found a Maclean's article from 1938 where the Minister of Health at the time, Honorable C.G. Power, he said, up until now, our efforts have been confined to keeping dangerous drugs out of Canada. But he talked with people in the United States, the U.S. Bureau of Narcotics, and they reviewed the ravages of the drug in the country right next door and declared that unless we wanted to go around shooting off large numbers of our population or being shot by them, it was time something was done here in Canada about checking the growth of Indian hemp. And even today, that was 50, 60, actually 70, 80 years ago. I read in today's paper, legalized pot could mean clamp down at the border, says U.S. drug czar. They're still continuing to try and dictate our policy. Parliament may be afraid to act because of that, but fortunately the courts are not down by that whatsoever, so hopefully they will come through for us.
Like they did with alcohol prohibition and women getting the vote and the end of slavery.
And abortion, that's what happened with
Abortion and death penalty in Cuba and Vietnam and DDT. We've led the way, Canadians.
There are questions that arise with respect to the classification of drugs just generally under the Controlled Drugs and Substances Act. At the moment, the Cabinet, not the Parliament, but the Cabinet, decides which drugs are put in the schedule and which ones are to be taken out. And the test at the moment in the law for doing so is if they deem it to be in the public interest. And that has been found in the courts to be a notoriously vague and unconstitutional term because it has no settled meaning. What does that mean in the public interest, especially when you couple it with a threat to somebody's liberty? Usually the law has to be more specific, more certain, more clear. There has to be criteria that you can measure so that you can ensure that the public officials are acting within their powers and not exceeding their powers. So another thing that may come out of this is that the government will be required to classify and set up criteria for all drugs that will have to involve this harm principle, so that an examination would have to take place of each drug as against the potential for harm to the public generally or to individual members of the public. And the harm would have to be such that it was sufficient to warrant the government getting involved to protect the public. And so we may be able to examine each particular drug against that criteria in the future to ensure that only those substances which pose a significant threat to the public or to others directly are prohibited.